I could sense it. Are they lie? They were looking at you angrily. If they had a way, they would have stoned you. They said House of Parliament has passed a law. President has signed. Then you, Mr. Ansari, you come and say that, oh, they should write entrance exams. Like, who are you? That's the question. Or, is that not what you said? That's what they said. Me, I heard them, but I mean, I'm a man of the people, so I'm speaking for and on their behalf. Entrance exams is scary, but he said we should not be scared, so you just write it. Me, I did one touch and I passed. So you too, if they say write, you write. Anyway, so we are back. Welcome back. Thank you so much. We are going into the next session. We are going to have another discussion, and to lead us, so that's going to be on legal and regulatory framework. That is we've done legal and regulatory framework. We are going to do accreditation and institutional readiness. So if you want to continue to do your professional law course at Central University, how ready is Central University in terms of infrastructure, human resource, and all of that? I have had a debate somewhere where I said, when we started free senior high school, it was a brilliant idea, but we rushed in executing it. Immediately we passed the law, we said, let's start doing it. And we saw all the challenges. What do we do so that we do not suffer the same thing with this law program? So that, should we have said that you run for 2 years and then we can work on the infrastructure, or we should say those who are ready with infrastructure, take it now. And then the others, if you are not ready, start building. These are discussions I will be having now. Very well. So let me invite our moderator, who will then introduce her panel, and then we can have the debate rolling. Ladies and gentlemen, with a round of applause, let's welcome Professor Alina Ameli Kasna, Dean of Students, Alumni Affairs, Central University. Your own Dean. She met me in the corner. Let's keep clapping for her. Yes. Our Dean, my Dean. Thank you so much. Should I help you? I'm out with you. Okay. Oh, fine. Okay. Good. All right. Okay. So, ladies and gentlemen, your moderator, your audience.
Good afternoon. You had a bit of your snack, and I believe that you are energized for this session. As has been said, my name is Professor Adelaide Na Ameli Kasna. I am your moderator for this second panel discussion, and our mandate is quite clear. We want to look at accreditation and institutional readiness. And the focus areas, we are considering governance systems, program approval processes, and then accreditation roadmap. So consolidate these in your heads and be thinking about how we can address these key 3 issues before we get out of this place. By way of preamble, I'd like to say that governance transcends different levels. In other words, different strata. So we can be looking at governance, maybe even from CLET's perspective. GTEC will also have to probably consider its governance, contributions. We are looking at governance at the implementation level, the institutions. And so as we debate, let's see how we can synchronize and make sure that we have a very smooth governance system that will facilitate the delivery of the courses that we are considering and remove the bottlenecks as much as possible. So we're going to be quite proactive here. The process for approval as well when it comes to the programs. So let's consider those, and that's why we'll have both GTech and members from the Bar Association here to speak to us. And then, if there is any roadmap at all, we can forge that out. Against that background, I'd like to invite to the stage our lawyer, Jude Tufo. He happens to be a lecturer with Ghana School of Law and also Central Law School. Lawyer Jude Tufo. A young-looking lawyer, but a powerful one for that matter. You're welcome to your seat, gentlemen. I wouldn't say my learned friend because I am not learned. Our very equally powerful speaker is in the person of Mrs., also a lawyer anyway, Mrs. Victoria Nana Ama Barth. She is the Vice President of the Ghana Bar Association and a lecturer at the Ghana School of Law. When I heard her on the phone, I told her she has a very youthful voice. We shall be privileged to hear from her. We have our discussant, who is our very own, the Vice Dean of Central Law School, in the person of Dr. Joseph de Graft Kwanzaa. Yes, powerful man. All very knowledgeable people in the area of legal education. The model that we're going to operate by is to give each of the speakers 10 minutes to do a presentation, since they have prepared on the topic, the areas of concern, and we need to hear them because whatever they have thought about before coming here is very relevant to answering our questions. So we'll give them 10 minutes each, and then after that we can have a little interaction. Then our discussant, so 10 will be 20 minutes, and then we'll interact for, let's say, some 20 minutes. Our discussants can come in as well for an additional 10 minutes. Then we'll open to the floor for questions. So, lawyer Tufo, or ladies first? Who will go first?
She's my senior, so I think.
Fantastic. I love that. I love that. All right.
Thank you.
Mrs. Bath.
This is one of the few occasions I'm eager to go first. You know why? Because the points will overlap. And by the time it gets to their turn, I would have said something hopefully smart. So good afternoon, and thank you for the opportunity to be a speaker at this colloquium. And thank you, esteemed moderator. Our task is to address you on 3 pillars: governance, program approval, and accreditation. If you don't mind, could I stand?
Please.
At that lectern? That's how I earn my daily bread. So I would like to do that. And hopefully when I finish, you give me some of the funds that you gave to your vice dean. Yes. Oh, no pressure. I haven't done anything yet. Thank you. I appreciate the love. So I believe we all know that Act 1170 has been enacted to cure certain shortcomings of the GLC, if I may say that with deference, in respect of the fact that the General Legal Counsel was wearing two hats, certain standards for legal education, professional legal education, and then also for practitioners. So now we have a dichotomy where you now have this Legal Education Act focusing primarily on legal education at the professional level. And then the General Legal Counsel maintains its oversight of the practice. So the rationale, again, of this act is also to create access, equity, as it were, because the perception and the reality at the same time was that the entrance exam at the sole institution that ran the professional law training was meant to be a filter and a barrier. As my senior has said, the exam remains not so much as a barrier, but as something that separates the chaff, the wheat from the chaff. So you have under the Act a structural change, which is the separation of legal education regulation, vested initially in the GLC, now in the Legal Education Council, Council for Legal Education and Training. And the Act sets up a board. So I'm dealing with the governance aspect now. It sets up a board, which is a body corporate under Section 1, and it has the capacity to acquire and hold property, enter contracts, and carry out all functions necessary for its objective of regulating the professional training space. That board comprises of about 15 members. The chairperson is a retired or is to be a retired justice of the Supreme Court nominated by the president. In fact, all members of the board and almost all members are nominated by the president because some also nominate others. So one nominee of the AG, the Attorney General, not below Chief State Attorney rank, 3 members of the bar, I'll leave it at that for now, with one of them being no more than 7 years standing at the bar. And I think that that is in recognition of the fact that the demographic of lawyers in this country at the moment is primarily comprised of lawyers in that bracket. So the purpose is for them to have a voice at the highest level of decision making when it comes to professional legal training. Then one member from the Ministry of Education, also appointed by the president, member from Ghana Tertiary Education Commission, a nominee from the 3 persons who teach law in accredited institutions nominated by the Conference of Law Deans. Then 3 representatives of the judiciary, one from the lower bench nominated by the Chief Justice, and then a retired justice of the Supreme Court and a secretary. The secretary will be the Director General of Legal Education. Members of the board can serve 4-year terms, renewable once, and under Section 6.5 of the Act, the president can revoke the appointment of a member by letter. So one has to be good or remain in the good books of the president. The board is required to meet at least once every quarter, and its quorum for its meetings is 7. Now, the board's composition, as you will see, is deliberately pluralist. It ensures that the Attorney General, who is responsible for implementation, is also not simultaneously the chair of the board. He has a nominee on there, but this time is a retired Supreme Court justice. And this is reinforced by 3 additional judiciary seats who are nominated by the Chief Justice, albeit appointed by the President. Then you have a National Bar Examination Committee. So currently we have the Independent Examination Committee, the IEC. That's not going to exist anymore under this act. Now we have a National Bar Examination Committee, which will be a dedicated assessment body established to administer examinations. So you see, you are in good hands. They are making sure that the exams are well set and properly regulated, and standards are such that when you write and you have prepared, you will pass. Now, that body will be comprised of 2 members of the board of the council. Then it will have 3 judges with academic backgrounds. 3 members of the bar in good standing with academic backgrounds nominated by the bar, and 3 academics nominated by the conference deans, Conference of Law Deans. So in total, an 11-member National Bar Examination Committee. Initially, some of us thought, why so much emphasis on academic background when this is examinations for professional training? But it does make sense when you consider that they are responsible for conducting examinations, invigilation, disciplining, security of scripts, handling appeals, moderating results. You do need some academic training, in how to manage these things, examination policies, etc. And these are reviewed annually. So the chair of that committee is also an appointee of the Chief Justice, and that person ought to have been a law lecturer for at least 10 years. And the members of the committee can also serve 4-year terms, renewable once. Now, the NBEC, if I may call it that for short, the National Bar Examination Committee, is functionally independent in its day-to-day activities from the council's administration. And its composition, with the chair appointed by the Chief Justice, connotes a significant commitment to assessment of credibility and independence from executive influence. You now also have the Legal Education Appeals Tribunal, and it is established as an ad hoc body under Section 79 to 86 of the Act. Its members are appointed by the Council's board, and the tribunal hears appeals against council decisions on accreditation licenses. It's composed of a chairperson with 10 or more years experience in legal education and 4 other members, each with 5 or more years experience in legal education. So the tribunal must convene within 30 days of receiving a notice of appeal, and its decision carries the force of high court judgments, albeit that when you are dissatisfied with the decision of the tribunal, you appeal to the high court. You appeal to the high court on matters of law. And the rationale is to strike a reasonable balance between accessibility of appeal and conservation of judicial resources. So you don't just rush to court in the first instance. Financial governance and accountability. The financial architecture of the council reflects standard Ghanaian public governance practice, where you have parliamentary appropriations, internally generated funds, investment returns, and donations. The Act, however, does not specify the council's funding quantum or minimum budget baseline. And this is important because adequate funding is a prerequisite for effective accreditation and inspection. And an underfunded council will not be able to meaningfully evaluate institutions twice annually across the country, because you will find that when you come to the accreditation process, there are several inspections that must be done by evaluation committees. So now I move to program approval processes. There are 2 levels. One has to do with institutional accreditation, which means, does this institution qualify to offer the law practice training course. And the other is curriculum approval. Does this program meet the prescribed content and methodological standards? And both levels are subject to council oversight, even though they operate through different mechanisms and timelines. So, the council in collaboration, and emphasis on the word in collaboration, because we are not too clear what that will look like or play out. But in collaboration with GTech, sets the accreditation standards. And when you look at section 22 of the Act, you have the standard categories. Library, you heard about it on the earlier panel, physical infrastructure, lecturer qualifications, student-lecturer ratio. However, some of these standards, the specifics of them are yet to be prescribed. So it creates a regulatory gap at the commencement. And until the council and GTech agree and publish the standards, institutions cannot know precisely what they must achieve. And I think on the earlier panel, that was one of the recommendations made. So the speed with which the council is constituted and publishes these standards will be critical to the operational success of the transitional period. Then you look at the two-stage institutional accreditation process, provisional accreditation and full accreditation. So for provisional accreditation, the institution, through its law degree program head, will submit a prescribed application to the council with information on administrative structure, curriculum and teaching methodology, evidence of standards, and prescribed fee. Then an evaluation committee will conduct a documentary review and on-site evaluation within a specified period by the council. And after this is done, if the institution is in substantial compliance with accreditation standards, is found suitable and competent to offer the law practice training course and presents a credible 2-year compliance plan with specific actions and execution timelines, it will be issued with a provisional license. And when that is done, it has 2 years within which to apply for full accreditation. I won't go into the requirements because I must leave some up for the two other speakers. I'll, however, move on to when you do get the accreditation license. There are 4 things that can happen. There's a comprehensive framework for license management after it is granted. So it can be suspended and restored. It can be revoked, and you have a right to appeal. Suspension may happen, for instance, when you are found to have presented false documentation or where you breach the conditions of the license. And you'll have 15 days written notice and that with reasons stated and of the suspension, and you have 10 days to respond or to remedy. So that will be a temporary suspension pending remedy. Then the council, if it is it reviews your response and it is decided that it must be restored, must do that within 30 days of the remedy being undertaken. Failure to remedy the breach or persistent non-compliance or failure to obtain the full license within 4 years. So if you don't migrate from the provisional accreditation to full accreditation within 4 years, post-grant, your license can be revoked. And when you lose that, that is when you can appeal and to the tribunal. And when you are not satisfied, you appeal to the High Court on law only. Compliance requires ongoing inspections, which I have alluded to. And then when it comes to curriculum and program approval, that is, again, the council's preserve. So the council develops a comprehensive Bachelor of Laws curriculum in consultation with the accredited institutions, and it must accord with contemporary legal services demands and recruit competent teaching staff. We heard about that earlier on as well. I don't know how much of my 10 minutes I have, so I'll go into my recommendations since I believe that there will be overlaps in our presentation. Now, let me start with the collaboration between GTEC and the council. It will be important to have an early memorandum of understanding between the council and GTEC, establishing agreed standards and a dispute resolution mechanism for where there is an impasse. I think on the earlier panel, the GTEC representative referred to where there is accreditation by council, but they also do not accredit. Where there's a conflict, that it would be useful if they can accredit in tandem. So it will require there being some memorandum of understanding and guidelines, and also what should happen where there's a dispute. Now, another recommendation, or perhaps a point that I want to note, is that there appears to be the perception that the Ghana Law School is now completely excluded from running the professional training course. I hold a different view, and it is based on section 77 of the Act that says that apart from the post-call, the law school will run courses, including, and I'll call you Professor Ansari, interpretation, expressio unius, I think may come in here. So yes, the lectures are available to be poached, but the baby has not been thrown out with the bath water, from my understanding of the Act. Now, the role of the Ghana Bar in this new architecture, I think, oh, my time is up. I'll stop here.
Yes, please.
Right.
So we'll take your views, especially on those issues when we do the discussion.
I appreciate that. Thank you very much for your attention.
A round of applause for her. Yes. Okay, so we've taken a bit of your time, but please, you feel free.
Good afternoon, everyone. It's a shame Senior didn't leave any apple for me. She has basically run through the entire act, so I don't know what else I'm to discuss. But most importantly, the governance has been discussed, the roadmap to accreditation, and also institutional readiness. What do we need? What needs to be done? So that is the focus of my 10 minutes discussion here. So what do we need? Okay, so basically if you look at the Act, and the discussion here is targeted at the institutions. So for instance, Central University, Mount Crest, University of Ghana, what do we need? Okay, so there are certain things that we need to take note of. We have the F, we have the I, we have the C, and we have the A. Okay, so the F, we have two Fs, that is a figure. The F, we have the financial investment, financial sustainability. Then we have the I, which is the infrastructure. Okay, then we have the C, the curriculum with the human resource. And the A is accreditation. Okay, so basically, with this new structure, so if you look at the position of the law, it basically allows the schools to have a law school with two different programs. Having a professional school to treat or to train students in legal professional training would require some financial investment in terms of classrooms, okay, lecture spaces or halls, and that is what the Act also requires. It is one of the criteria that will be used to determine whether indeed an institution is ready and should be granted accreditation. Okay, so do you have that money available? Is that investment ready? These are decisions that needs to be made ASAP. And this is important because immediately after the president signed on this bill from the 12th of May 2026, the Act became effective. Are we ready in terms of rolling this out? So that is the investment. Again, we are also looking at the recruitment of lecturers. Interestingly, we have looked at this act with the sole focus on the professional aspect, forgetting that the changes also affect the LLB degree program. In that now, there are some professional courses which would have to be taught at the LLB level. So in terms of recruitment, focus has generally been at the professional level, which my predecessors, speakers have already spoken about in terms of poaching experienced practitioners and what have you. But we shouldn't forget that we would also need same for the LLB level to teach ethics, to teach, how do you call it, say, company and commercial law practice, to teach interpretation. Okay, all of these courses have now been removed from the professional stage and have now been brought to the LLB, that is the academic stage. So I would make a recommendation before I move on. So in terms of the investment focuses on the physical structures. It also focuses on the human aspect, that is the human resource capital. And here the recommendation is that the institutions should not just target the too old. Let me put it this way. We shouldn't just target those who may be 10 years or more at the bar, especially for the LLB courses that have to be taught. Okay? We may consider those who are 8 years plus with a lot of experience in the courtroom and also with teaching skills. This is important. Teaching skills. Teaching skills. Because you don't want a situation where poor investment would lead to students finishing LLB, then they will jump on to this new program and they'll be creating problems for at that stage in terms of their appreciation of what is going on. And I say this because even now, due to the mock that was conducted for those who are currently at the Ghana School of Law, and also because of the high numbers that were admitted this particular academic year, there are a lot of students who are still struggling with simple things like IRAC. So the investment in terms of the recruitment of the right lecturers is important. Is important. Then I come to the I. The I is about the infrastructure, and these are capital expenses which would require probably board approvals from most of these universities. And these are roadmaps leading to obtaining accreditation. The institutions board or these governing boards, are they in place to make decisions as we speak now? Have they looked at the law in terms of the things that we need? Now the requirements are there, spaces, and the law is interesting. It says that we are not asking you to put up new structures, but you should make spaces available even where those spaces are also to be used by others. We don't want impediment. We don't want competition. Is Mount Crest ready? Is Central University ready? Do we have spaces for this LPT? Do we have that? What decisions are we making now? Okay, so these are things for these institutions to think about. Okay, and they are important because without that, we will not be able to get to where the accreditation, whether it is initial or provisional, and eventually the final one. Okay, so these are important, and without them, we will not be able to get the accreditation. Then we have the curriculum, the C, the curriculum. So we have the LPT, then we have the LLB. In terms of the LPT, the curriculum has now been determined by law. I think it is just 5 modules. The civil procedure, criminal procedure, we have accounting and legal professional management. Then we have, there are about 5. Yeah, not ready to come to mind, but 5 of them. These 5 models, are these universities waiting to look for new lecturers or new lawyers? There are about 12 or so LOB institutions in Ghana from my checks. 12. Most of these universities or these institutions, if I can put them that way, would be looking for, that is those that run law programs. They will be interested in looking for lecturers who will be able to take up this professional aspect. With this professional aspect, and with these lawyers that they'll be looking for, the question is that, are they waiting or are they pushing them now? It is important for the institutions to know that there will be few lawyers or professionals that will be available for these institutions. Because the number of lecturers currently at the Ghana School of Law teaching the various courses are not many. Even with the huge numbers. If I take even the course model that I tutor, which is company and commercial law practice, the lecturers are about 8. And if every school needs about 3 lecturers for one model, can you imagine the numbers that will be left for the institutions to be going after? So in terms of which lecturers to go for, and this is important because section 22 tells us that the council will determine the qualification needed needed for you to be able to lecture. Okay, and the earlier speaker, Dr. Kusi Apia, made a point that she recommends that it's 10 years or more. I don't know what the council, what GTech and the council will come up with. But if it is 10 years or more, there would also be there will be a need for the universities or the institutions to also consider lawyers who have that capacity in the law firms. But again, in doing so, this is advice. We should not be in a hurry to just go for practitioners who may come to the classroom and not be able to teach. I've seen it many times. There are some practitioners, they are very good, but they cannot teach. They will come to class, talk about their cases, talk about how well they are doing in court. Lectures will end and they will pack their bags and go away. That is not the kind of lecturers institutions should be looking for. We should get lecturers who can impact. That is important. Impacting knowledge. And that forms the basis of the curriculum, the C. And the A is that we shouldn't be scared. The universities, you have most of the resources as at now. I would say that on a scale of 1 to 10, most of the schools are about 4 or 5. Okay? Especially for some schools, they may be around 4 or 5. Okay? So this is the time for you to ask your certain questions. Okay? It's just like going to a doctor. What is wrong with you? Okay? So if you want to get this accreditation, what do we need to do? Okay? We need to carry out an assessment to know the exact things that we need. So we may have a plan in terms of what do we need to do to get to the accreditation, maybe within 2 years or within 3 years. So that in the 3rd year, we'll be sure that we'll be ready to put in that application. So we need an assessment. Then we also need to, after an assessment and knowing exactly what we need, then we may consider to roll out to look for the things that we need. Is it infrastructure? Is it lawyers to fill up the LOB and also the LPT? Okay, we shouldn't forget the LOB. They are lecturers, professional. In fact, we need practitioners at the LOB level to teach certain courses that have now been brought there. Okay, so let's not forget that. Okay, and again, the issue, I think the question was asked, I don't know if my 10 minutes is up. A question was asked about whether there will be competition or not. Okay, so that question really intrigued me, and I think I want to add something more, something little to it. The system we have introduced is not different. So for me, it is a combination of the UK system, that is England and Wales, and that of the American system. Because some years ago, the English system had just one law school, Inns of Court. And in Ghana, we also had one law school, Ghana School of Law. Then came at 1170, introducing a system where universities or institutions can run professional programs, which is what is happening in England. Okay? If you don't want monopoly, competition would be introduced. So whether we like it or not, competition has come, and it has come to stay. If you want to stay ahead, what do you need to do? Recruit right, get the best infrastructure, get the best materials in terms of textbooks, in terms of facilities, get all of these things in place. And most importantly, Kudi, for the lecturers, we need money. Kudi, l'argent, we can't come and you pay us X Ghana cedis per an hour. Whatever you decide to pay must be commensurate with the what? With the rate on the market, or should be at least conform to what is being paid at the Ghana School of Law. All right. So on this note, Madam Moderator, thank you very much.
Thank you very much, Lawyer Tufo. Your energy is very infectious. Thank you very much. I'd like to ask a question of Mrs. Bath. You talked about the examinations committee that, will be put in place. Do you envisage any conflict or micromanagement, from that level in terms of governance? From that level, upon the impinging upon the universities, that will also be setting the questions and so on. And if you envisage any challenge, how can we mitigate those challenges? They have examinations committee. They're going to have an examinations committee. And you talked about the fact that they might be, looking at questions and reviewing and moderating and all that. There could be some overlaps with the institutions that will be running the programs. And how do you think we are going to make sure that they do not impose or micromanage? Because they will not have a full complement examinations, lecturers and experts, although you did say that members of the committee are going to be people who are already in lecturing, but still.
So I expect the National Bar Examination Committee to have policies in place that will regulate things such as conflict disclosures. And let me digress a little, because where I really foresee more of a conflict issue is when it comes to the accreditation. And you have certain members of council, the board of council, having an interest in the institutions that are seeking accreditation. At that level, there has to be disclosure and exclusion from the decision-making process. Likewise, when it comes to the examination committee, I am not too concerned, because if I consider what the current system has tried to do, even though it is not perfect, the Independent Examinations Committee has tried to remain very independent in terms of how it runs its processes. So even in its composition, you are not going to have that kind of overlap. They ensure that those who sit on that body are not also part of teaching staff or have anything to do with the institutions whose candidates will be writing those examinations. And if that mechanism has not been put in place, it will definitely have to feature in their policies and how they put their structures in place. But what we have currently in place, which is going to be replaced, has tried to follow some best practice in terms of ensuring that there's independence, not just on paper, but in reality. So it will all come down to their policies, which will govern their mandate in administering examinations, in ensuring that there's no conflict and there's also full confidence in their process, because now they are the sole entity, even though under the umbrella of the council, that will ensure that anybody coming into the profession is having a fair access in terms of the exams that they write and how it is graded, and how the results, etc., are published. So I think the conflict will always arise in one situation or the other, but it comes down to the governance mechanism through the policies that they put in place.
Okay. We know that the universities initially, apart from the practical aspects of the legal, education, the universities, they have been under GTEC. So GTEC has wielded some governance or oversight or regulatory power. Do you envisage any, again, you talked about conflict, so let me look at, do you envisage any conflict, and how are we going to forestall such if it should arise? I mean, in governance, any possible conflict that could arise? Maybe either of you can take it up. Yeah.
Okay. Can I?
Okay.
Yes. Obviously, we are speaking about the governance structure, program approval process, and accreditation roadmap. But I'd like to add my voice a bit to what my colleague panelists have said in the past. Now, I foresee a two-tier governance system. The external governance system, which the Council of Legal Education and Training provides alongside with GTEC. And obviously the appeals tribunal, where decisions of the Council of Legal Education and Training can be appealed to. But internally, within the institutions, I believe that we have a governance system as well. And of course, every accredited institution or law faculty has a governance structure within. And of course, the current act, the Legal Education Act 2026, Act 1170, has introduced additional measures, as it were, to increase the governance structure. For example, if you look at the role that the dean of the law school should have, that is, in my view, some governance structure there. Now, you also have the introduction of a finance, an accountant. Also, we have the administrator and staff that should work with the administrator. These are all different levels of governance structure there. Now, going back to your question as to whether there is a conflict of interest, when Professor Oklu spoke, professor from GTEC spoke earlier, you could see that he had tried to make us believe that there would be some kind of a seamless approach in terms of the work that GTEC would do and that of the Council of Legal Education and Training. We are yet to find out whether that actually plays out. In my opinion, I think that the Council of Legal Education and Training should concentrate on the accreditation of the professional program, that is the law practice training course, and that the GTEC should concentrate on the LLB. Now, in the Act, specifically Section 3, that says that the GTEC and the Council of Legal Education and Training will collaborate with each other, setting the standards for faculties of law schools to follow in order to seek accreditation. So it remains to be seen. But I think that there will be an issue, or there would be some kind of conflict, but I believe that they might iron that out in due course. Now, if they should stick to their separate, as it were, tasks, in other words, if the Council of Legal Education and Training should stick to the accreditation of the professional program. And then GTech stick to the accreditation of the LLB. I think then we wouldn't have too much conflict in that regard.
It sounds neat. I'm just hoping that we don't have any turf fights. And because over the years, GTech has been, they've had oversight of the university. So now that the professional programs are coming on board, they shouldn't, but I'm sure now that we are thinking things through, we'll navigate those waters quite smoothly, and there should be harmonious, approach to the whole thing. Before you talked about some new courses, ethics also included, and quite interesting. And whether we have enough lecturers. I was amused when you mentioned for a particular course there are about only 8 and all the rest of it. So what solution would you prescribe for us to increase the numbers? Because other universities are waiting. I can feel the excitement that they will be running the professional, programs. So what do you say so that we get ourselves ready as well?
Thank you. So in terms of the lecturers and also getting the right personnel, sometimes it's also all about past student, okay? Because these lecturers won't come from anywhere. The first set of lecturers to start the LPT are lecturers from the Ghana School of Law, okay? And I'm sure that the institutions that are interested in poaching the right lecturers are also going around and speaking to the relevant people, either at the Ghana School of Law, or the Ghana School of Law themselves will be happy to pass on quite a number of them to the institutions, but they can't keep all of them as of now because of the position of the new law. Okay, so in terms of moving forward, the institutions must act fast. That is, if they really want to be part of this new legal order, institutions must act fast in terms of getting the right personnel. So that is basically what this is about. I think one earlier speaker, the doctor from the UPSC, had mentioned that they are scouting. Yeah. But for me, don't scout. You know the right people. Just go in there for those people. That is what I was saying. Right.
See.
I just wanted to add that I think on the bright side, what this means also is that with this influx of aspiring lawyers, some have to focus on teaching law as a career path because it's definitely going to be lucrative in the coming years. And you have to be deliberate about it because at the law school, the model that I went through when I started teaching there was that I understudied a senior lecturer. I started as a tutorial master or assistant, as you'd call it. At the time, I hadn't attained the requisite number of years. But by the time I did, I had already acquired enough experience to start moving on my own. So yes, they say 10 years. You may be 5 years now, but follow someone around, develop an interest, take certain courses about teaching skills. And that's an important point that you made because in fact, whatever practitioner you are, you also need to be oriented in how to deliver the subject and to deliver it effectively and even how to assess. So let's also look at the bright side of this, that some people have to be very deliberate to now say, look, we're going to go into the law profession, but our focus is going to be on teaching the law. We gain some practice and we go fully into that space. And likewise, the same with what you mentioned, gap analysis. Fortunately for some institutions, the transition period means that a certain category of students will still be going through the law school for the next 2 or so years. So this is the time to raise capital. This is the time to recruit trainer of trainers Yes, there are a few staff out there, but they can come in and teach. And in fact, you have to have succession planning. People in the pipeline who are on the verge of attaining the number of years in teaching, who can step into the shoes of the very few that everybody will be targeting. So yes, the prospect, the thought of the numbers is daunting, but there's also a lot of opportunity.
Dr.
Yeah.
De Graft Kwanzaa, you want to
Yes,
add
I
something?
just wanted to add my point of view, especially with the point that my colleague panelist, Mr. Tufo, mentioned. There is a dearth of available and qualified legal practitioners who can teach at the various law schools. Now, you will remember that he made a point earlier saying that even at the Ghana School of Law, there are very few lecturers there who teach quite a number of students. Now, these are the very same lecturers that institutions like Central University and maybe other institutions that might want to seek accreditation to teach the LPT. These are the same lecturers that we might want to go and poach. So if you look at the qualifications criteria set out in the Act at 170, then we will have a problem because we wouldn't have enough lecturers that would go around in terms of qualification and availability to teach on the accredited programs of these institutions. So I think that there should be a way where maybe CLET and GTEC may alter their position. Of course, the law has prescribed, but I don't know whether there could be an amendment or maybe there could be a provision within an LI that might follow that will clarify the situation so we can have quite a number of lecturers available to teach on the LPTC program.
Thank you. It looks like we've talked about infrastructure, finance, curriculum, accreditation issues. We need to disaggregate those as well. And I was wondering if there is a checklist, for instance, infrastructure. What do you think it should comprise? Either of you can handle it. Yes, infrastructure.
Infrastructure-wise.
Yes, we are talking moot
Yes.
courts maybe and you
Yes.
know, clinics and so
Yes,
on.
I'm happy to say that Central University has actually already conducted an assessment of the current state of affairs in terms of infrastructure. So we've dealt with that. Of course, we need to set in motion the plans to ensure that where there is a deficiency, we upgrade. But when we talk about infrastructure, or when the Act talks about infrastructure, it basically refers to the physical facilities that are available within the institution. Apart from that, you'd also need to have available lecture offices or offices for lecturers. You also need to have big classrooms. These are all part of infrastructure, in my opinion.
Just to add on, so we are in a transition period, and during this period, so I reckon that the best approach to be adopted by the institutions would be to maintain what they have now. Okay, because no school will be ready to put up maybe a 5-block offices or classroom, because the law also makes provision that you can, if you have available facilities, so long as they are not the subject of competition for spaces, they can be used. Okay, so during this transition period, it is about the allocation of time and also allocation of students in terms of when maybe you want to introduce certain courses to this group of students who may be initiated to this LPT for the first year. So, like I earlier stated, the transitional period is important, and that it is also for institutions to assess themselves whether indeed they would have to convert existing structures to cater for this LPT, or they need to develop new structures. So the assessment, that is a diagnostic stage, is important. Okay, like and I'm saying this again, there is no need to rush. We are okay. We are fine. Because there's already an existing platform for us to get to this accreditation. Let us not rush. The platforms are there. There are some issues that may have to be resolved. There are lecturers, except that we need to push them, or we need to look for them, or we need to scout for them. In terms of the infrastructure, the position is that the assessment, the diagnosis is important, so that we determine whether we want to put up a new library, we want to put up a new system for new legal databases, we want to establish or purchase legal AI systems. These are decisions for the institutions to make, but the assessment diagnosis is important. Thank you.
And thank you very much. I'm going to throw the cat among the pigeons here. You talked, or the previous panel talked a lot about collaboration. And off the top, as they say here, of my head, I'm thinking if we have a good bus, and maybe another university has got quite a number of moot courts and top class. Can we collaborate with them so that we use their facilities, and then maybe other lectures we run on our own until we build and get what we need? I'm looking at different scenarios, even in our in our country, or even nursing. We used to hold some of our examinations in maybe other hospitals. So can the board or the council consider as they accredit the provisional accreditation, for instance, at least at that stage, until maybe we build? I know self-sufficiency is essential, but can we do that? Can we consider that?
So if I got you right, so in terms of collaboration with other institutions.
Exactly.
For me, it is easier said than done. The individualism is what is at our heart.
Exactly.
This is media. I know Senior Professor Ansar is here. He spoke about collaboration. It is an area that is likely to breed dispute. Let's not go there. For me, respectfully, we shouldn't go there at all. The institutions must work on their own to get wherever they want to get to. Collaboration is important with respect to sharing experiences and expertise, not platforms. My respectful opinion.
Let me just say that collaboration can also be for remuneration. And I use the example of the Ghana School of Law. When its infrastructure constraints required that it had several campuses in Accra and even outside Accra. So GIMPA offered facilities, but of course at a fee. So I think it will not muddy the waters where you stand. When you stand, you can make some money from someone coming to use your moot court premises until they can have their own. I do acknowledge that because this is the infant stages and everybody is sort of guarding their turf and how they get ahead of one another, they may not be so open to collaborating, but it is also the future. However well resourced you are, sometimes when you are able to partner with another institution, you are stronger in how you step out. So I acknowledge that it's going to be an issue, but I think we should explore certain resources like libraries, etc., that Dr. Francisca talked about. I think those can easily be shared. And then, of course, the rest, why not charge, but at a nominal or moderate fee? Please
yes, and if I may add, on the issue of collaboration, I see a bit of a difficulty there, a challenge. However, I also do believe that we can collaborate. All faculties that are seeking accreditation can collaborate in the context of the curriculum. Representatives of faculties at the Conference of Law Deans could devise a curriculum that will be a common curriculum to be adopted by all faculties. And in that regard, I think there will be collaboration, which will be very helpful to the accreditation process.
There's one thing that I wanted to also highlight, because it's also a consequence of when you reach the conditions of your accreditation license. Now, the law makes the sanction, the burden of the institution, as opposed to the individuals who are at the helm of affairs. And is a fine of about minimum, I think, 600,000. That's 50,000 penalty points, and maximum of 1.2 million. So I think it's a good thing, because when that kind of sanction rests on an individual, the structures can be lax. But when we know that it's going to hit the entire institution, then we ensure that we have the right policies and structures in place to maintain that license on the conditions based on which it was granted.
Thank you very much. A lot of knowledge poured out, and because we are time constrained, it won't be too fair not to allow the floor to at least 2 questions from the floor. 2, please, 2. Please show by raising your hand.
Okay.
The dean, Professor Atefua, wants to react.
My lady, would you want to overrule Dean so that I rather go to the back and take from the audience?
All right.
Thank you. Dean, you have been overruled. Yes, I saw some hands at the back. Okay.
Thank you, panel members, for that brilliant suggestions and discussions. Listening to you and the earlier panel, I see the issue of collaboration. But I also believe that competition also brings us quality. And so I get a bit worried, especially if universities must come together. Isn't it going to be an avenue for low standards? Because just like the professor in the GTech panel said, sometimes they present ghost names, they present facilities that do not exist. Just like the Chief Justice said, one of the key, things that this act is bringing is to bring competition. So if Central is doing well, and we are attracting more students, and our students are passing the bar exams and are being called to the bar, I think it is going to serve as a learning point for other universities to also learn, so that they will do as we are doing, rather than just looking at just coming together just to meet a standard or just to get accredited. I don't know what the panel members think about this.
Thank you.
May I give a brief response?
Can I just take everything that you can, so that do I have a hand from this side? Okay. I wanted to see if I can balance it up, so forgive me.
Thank you very much. Madam Chair, my concern is, it goes this way. I've not read law, I am not a lawyer, but if I listen to the discussions here and on media, this law is about access. It's about access. Again, law education is about development. And at our current state now, providing the access requires a deliberate implementation steps. Making the law relevant to our development also required deliberate movement. And where we are, and the discussions that we are short of teachers and so on and so forth, requires some considerations to move this agenda. Not all those who receive legal education are going to the courts. If we look at our administrative level, we need lawyers there to guide some of us who make decisions. At our social level, how many lawyers is it to the population? and we need legal services all around. But if the conversation keep talking about going to court, perhaps we may not also make the law and the education we are talking of relevant to our development. So I want to appeal to Prof, the deans and those who matter here, that the discussions and the implementation to open up so that we can have legal education as it is relevant to our various spheres of life. Else, the position that we are training lawyers that they go to court may still not connect to our social needs, and therefore we may not also get what we want to get from legal training. Thank you.
My lady, do you want to take from 2 students at the back before I bring the microphone? Okay. Since the dean's hand is up, earlier I was threatened that he will collect my certificate.
Thank you very much, Madam Moderator. Let me take it from the last speaker. We are a creature of statute. The university itself has statutes, and we operate under law. One of the laws we are going to have to operate under almost immediately is Act 1170. Act 1170 prescribes curriculum. It prescribes a revised LLB, and it also prescribes the law practice training, the LPT, before you ride the bar. Whether you intend to practice law or not, this is what the law is as of today. That is what we must train our students on. Then when they become lawyers, they may elect not to practice. But every good lawyer, the law envisages, must be equipped to be courtroom ready as well as boardroom ready. Every good lawyer ought to be capable of advising his neighbors to get out of trouble. And that advice to get out of trouble or to foster good neighborliness includes the ability to anticipate what a court is likely to say if you didn't resolve your differences and the matter went to court. So a good, well-rounded lawyer, whether they practice or not, whether they do advocacy or not, must have a sound appreciation of what goes on in the courtroom. That is why the framers of the law have revised the LLB such that if you finish the LLB and you elect not to go forward, but you go and do philosophy and become a socio-legal scholar or something, or researcher, you would still have had the experience of doing clinical legal education, that you would have been able to advise market women at Agboboloshi on how to enter into and run small businesses, how to register companies, how to do things, not necessarily because you are in the courtroom, but because good interpersonal relations. You want to run your small business well. You want to stay out of trouble. So that's one. I think our focus ought to be, how do we prepare to get accreditation to run the revised LLB? How do we position ourselves to get accreditation to run the LPT course? As for me and my household, we have started preparing to be with the Lord. Accreditation processes are outlined. Details will be fleshed out by the council. But for now, we all know that you must have infrastructure. We know what those are. You must have rooms to hold conferences with clients. You must have moot courtrooms that mimic proper. You must also have lecture rooms that are adequate and spacious. And you must have libraries that are also physical and virtual. And that is where the second issue comes in. Central University has all of these, and we can expand on them. this whole campus is available to become one law school par excellence. And that is something we can and will do. The other part is the cooperation. I am an eternal optimist. There's nothing, thanks to God, I've been part of that has failed. Even when the angles and processes seem too daunting and unbelievable. When we started revamping the national education system, nobody believed it would work. We believed it would work. And we are the #1 country in the world, apart from Estonia, to have the kind of Ghana card that we have, with the multiple functionalities, the reliable technical system, impregnable. We've done it. And we did it through a public-private partnership arrangement that others, naysayers, were saying it won't work. I believe in cooperation. I believe that when well-intentioned men regulate their relationships to a common end, and they are guided by the framework of the law, it works. So if Mr. Kweku Ansari here, or the Dean of Gimpa Law, the three of us decide to cooperate, or with the University of Ghana to collaborate, why? We have enough common sense, enough brains to also write for ourselves a memorandum of understanding that will anticipate the pinch points and try and smoothen the ends and regulate them so that, why? It will work. As we go along, problems may come. If we are unable to resolve it amongst ourselves, then we'll go to court. But we ought to put our best foot forward, put in our best efforts, believing that we can forge sensible, reasonable, workable partnerships. But you go to the table prepared, properly prepared. So if you're going to forge a partnership or have collaboration with others, you must get your own house solidly ready. So you have the checklist. And I say to you, the students of Central Law School in particular, we have created a committee structure within our advisory board system. Every aspect of what it takes to be successful, we've mapped it out. We have committees that are going to deal with them. That's why we have assembled an advisory board that comprises solid people in their backgrounds. They will help us retool, recalibrate, and put together a structure that works. So if we go to meet with the University of Ghana, they should be surprised by our level of readiness. They should be super impressed that we have put in place the mechanisms and arrangements. And then when they bring theirs, whatever university it is, when they bring theirs and we try to conjoin, it will work because we'll be well-intentioned, we will be meaningful about it, we will operate within the framework of the law, and God, the Lord, will also be with us.
Thank you so much, Prof. Yes, so I'm going to take two from the students. I have one
Umaru,
hand
please,
up
can
here.
we take only one so we return to
Okay,
Prof?
very well, very well.
Yes,
All right.
thank you very much.
Hello, everyone. So my name is Celestina, and I'm a level 400 student in Central University. So I just want to know what's the way forward for us, like level 400? Because I've heard some people have told me that we are coming back to school in September, and I want to know whether as level 400 students, in completing our LLB degree, can we also apply to other law schools? But basically, what's the way forward for us? What should we expect? Yes, especially in Central University. Yes, please. Thank you very much for the opportunity.
Thank you. Dean, TK, please take it over.
That's the last
Yeah,
one.
so we return to Prof to
Yes,
wrap up.
Please, you have your closing remarks.
Oh,
Or you want to react to what they
Yes, just
said?
briefly.
Okay,
So
briefly.
So I think I can put it together. Closing remark
Yes,
and
on
response.
the first comment, I wanted to say, the sole objective or the driving force behind this new law was access. And if we are not careful, at least in the transition period or the infant stages of implementing this law, we will reproduce a different kind of inequality. Why? Because there will be disparity in the resources of the various institutions that will be offering the training course. And that can also mean that whilst we now have one exam that is a leveler, putting everybody on a level playing field, the quality of instruction and delivery will not be the same because some have more than others. And so why not have a bigger objective? Because currently there's more fish in the sea than any institution that is accredited can accommodate. If you look at the interest in reading law, so share resources in the interim while others build capacity. Prof. Atefa has addressed your point, but I wanted to also put out there that in Ghana, we qualify as barristers and solicitors. So of necessity, every lawyer who comes out of law school or the new system that is coming must have courtroom training, whether they intend to use it or not. And that necessitates having the resources for the institutions running it. Now, the last question. There's a transition period. When you finish level 400 and the institution where you did your LLB has not yet been accredited, you may apply to take the training course at the Ghana School of Law. That's in section 93 of the Act. So take a look at that. In conclusion, giving my remarks, I want to say that because there's a lot of concern about the examination, the members of the National Bar Examination Committee will have to be genuine experts. It's not just that you pick 3 members from the bar with academic background or 3 members here and there. They must be genuine experts. Their methodologies must be periodically reviewed against international standards. They must publish examination statistics, pass rates institution by institution, performance analysis, and trend data, because that will enable targeted support and public accountability. And I think the temperature of or the level of fear will decrease and students will be better advised also in which institutions they choose. Thank you.
All right, thank you. So in all, at 1170 is good. It has introduced access, but there's some small danger. Let me not burst your bubble. This is to make Professor Ansari happy. There's exams at the end. There's exams at the very end. So apart from the internal exams by the institutions, there's an exams at the end. That is a leveler. So please take notes. That is number 1. Number 2, the mere fact that you may have graduated with an LLB from an institution may not automatically qualify you to enter to do a legal professional training course with that same institution. Because once competition is introduced, schools will be looking for the best. So the mere fact that you may be with Central will not automatically mean that you will be what? Graduated to what? Central LPT. Okay? This system, like I'm saying, it is very similar to the UK system. Okay? And again, on the point of competition, this is important, especially for students. Please take note. There's exams at the end. So access is there. So you enter. At the end of the day, whatever it is, take your materials, your studies seriously, because it is not automatic. National bar exams. Senior counsel has mentioned or spoken a lot about national bar exams and their body and what they do. They are there at the top. Okay, so take notes on that. All right. So I think on this, we are all happy with at 1170, and we hope that, for me, I know that the inequality will come because of the competition. So the institutions, what are you doing? Prof has mentioned the checklist. May I call it the diagnosis, the assessment? Thank you very much, Madam Moderator.
Thank you very much. Dr. De Graft, Kwanzaa, you have anything to say?
Yes, just a very quick one. I believe that Act 1170 has come to stay. We have to get ourselves prepared and run the race for accreditation. I think that's what I just need to add at this point. Thank you.
Thank you very much. By way of closing remarks, I would also add my voice to the fact that Act 1170 has come to stay. It has opened more opportunities for all tertiary institutions, particularly the universities that are already running the law degree programs, to also get on board in training the professionals for us. And as it was said, it's a national service. So we will do it to the best of our ability, and we will ensure that the lawyers that are put out there are of the highest, standard. For me, I'm very happy that Central University has taken this leadership role in discussing the dynamics before we even implement the whole works. And we believe in integrity. We have faith as well, and excellence has been our hallmark. So I know that as we are trailblazers, we'll tease out the best, we'll do our checklist so that when, whether it is CLET or G-Tech that comes, we will qualify even beyond their expectations so that we will pull others along. I wish to thank our panelists, Mrs. Let me start with the lady, Mrs. Victoria Bath, and then lawyer Tufo, our own, and most thankfully, I am grateful to Dr. De Graft Kwanzaa. Actually, he was involved in also crafting the law 1170 in the debates and all that. So we are happy. I'm grateful to the audience and the participants. Most importantly, our Vice Chancellor is here, Professor Dateba. We are grateful to you. We're grateful to Dean of Central Law School, Professor Atifwa. Thank you so much. And thanks to all the dignitaries. Your presence has made a great deal of difference, and a lot of knowledge has been exuded, and we really are grateful. We believe that it will go a long way in shaping law education, and especially the professionals for this country. Thank you. God bless you abundantly.
Shall we do it better? Very insightful presentations. Ladies and gentlemen, I had wished that Umaru did this, because I don't want to come across as the bearer of bad news. We have to take a detour instead of the lunch. So I'm not looking at anybody's direction. Instead of the lunch break and networking, I have been instructed to call upstage the next panel so that we have this, and then immediately after there will be lunch. For this reason, we're still keeping the ambulance here so that just in case, if I may invite the moderator for this program, this segment, Dr. Doreen Adumaje, lecturer, Faculty of Law, Kwame Nkrumah University of Science and Technology, and she would invite the lead speakers and the discussants.
Okay, thank you, TK. The good news is that lunch is packed. So on our way out, we just pick our food and then we leave. Time has not really been kind to us today, but it's an important exercise, so we'll try. What I have to now say, though, is to set a trap and say that the number of minutes that Doreen deals with her panel is how much time we have to wait before we eat. So when her panel is going on and on, you can start doing. Thank you so much, my lady. Over to you.
Why'd you push the burden to us? Okay, thank you. My name is Doreen Adoma Ejay, as I've been introduced. And for all that's been said already, we will not reinvent the wheel because most of the issues overlap. but we would rather focus on the germane issues that were not touched on. And for our session, the focus areas are on curriculum development or redesign, faculty infrastructure, and then, yes, faculty and then infrastructure. And please, I have the honor of being joined by distinguished guests, and the first one being Mrs. Susanna Efutu. Can you please come up stage for us? That's a loud applause for you. Thank you. And next would be Mrs. Francisca Yaba Asante. Unfortunately for us, the third speaker could not make it. That's Dr. Budu Ajeman. So it becomes a women's affair, and we are happy to host that. That also limits our timing, and for our session in particular, I would want us to engage the students more, so we deal with you and have more time for you. Thank you for that. Okay, so if I may start now, we wouldn't go so fast because a lot has been said already. We would now focus on the redesign of the curricula, particularly the LLB, because the statute sets out the curricula for the LPT, the redesign of that, and then faculty and staffing recruitment for the faculties now because of the new phase that has been given. And last, on infrastructure, that has also been discussed at length, so we just touch on the germane areas that were left out. Okay, so that is my introduction. I'll start with my first speaker, if I may, with Susanna. And by the way, we used to be at the faculty around the same time with Susanna, and I'm happy to reconnect with her one more time. So on the curricular redesign, you have a paper? Okay, yes. So give us your introductory remark. We'll be happy to hear that before.
Okay.
Yeah.
So, by way of introductory remarks, as has already been said by our predecessors, those who were here before we came, the Act 1170 has, brought about significant changes in what was previously being taught at the faculty level. And the opportunity has been given to institutions to run the professional program, which hitherto was just being run by the Ghana Law School, which means that the institutions will have to look again at the courses they are doing. And one interesting thing about the Act is that the Act is silent on how long the LLB program should run, whether it should be 2 years or 3 years or 4 years. But it's very clear that the LPTC, which is the Law Practice Training course, should last for a year. But how long the LLB, the undergraduate's bachelor's degree in law, should run is the Act is silent on it. And we understand because we are doing 4 years now, and now some courses have been scrapped from Ghana Law School, being brought down. So the challenge is it going to be 5 years, or are you going to adjust your curriculum such that you are able to accommodate it within the 4-year question? That's the big question right now. Yeah.
Thank you very much for that. Can you give us opening remarks before we start, if you have any for us?
I am here to speak as a discussant and on the issue of library. I am not a legal learned friend. So I am a friend of the learned. So I am very happy to be here today and to sit in for all the discussions. And one thing that runs through all the presentation is the fact that we have to have good resources, both physical and electronic resources. And I am very happy I heard about collaboration, and that was basically what I was also coming to say. I was also advocating for open access, because you realize most of the information that have been gathered together and people are selling it, they are open access. They are information that are available, and people are just have taken the pain to sit down and write, put everything together and commercialize it. So I think Central University, we are on the good path with regards to our infrastructure, our library resources. Yes, we said that no library is self-sufficient. So Professor Tefa said it. We have the infrastructure, we have the resources. We just have to develop on the resources. Thank you.
Thank you very much. When the second panel members were having their discussion, Jude Atakwa, yes, he passed a comment that I share with, and that is that when I read the statute, it's more of a blend of the UK system and the US system. So now my question is to you on the redesign of the curricula. How are we going to manage it? Because already most of the courses we run at the LOB level, the students seems to be overwhelmed. Now we are pushing much more to add to it. How do we manage that in the redesign so that we do not overwhelm the students, but at the same time also we also remain responsive to Ghana's specific legal education demands or legal system demands? How do we blend the two?
Yeah, so like I mentioned in my opening remarks, institutions may consider a fifth year. It's really in their discretion because the Act is silent on it. So they may consider a fifth year for some of those extra courses like family law, interpretation, etc., which are now being moved from the professional level to the first degree level. Because that is one pathway. The other pathway may be to squeeze the already existing 4 years and see how they can accommodate those courses within the 4 years. But that's an arduous task. First of all, taking into consideration the level of mental capacity that you need for a course like interpretation. You know that in the law school it's done in the second year. And so thinking about students in undergraduates doing a 4-year LLB program, being asked to do interpretation, well, it may be possible, but it could be challenging. So those are some of the things that we have to look at.
Okay, so that is where a law school or faculty decides to run it for 5 years, as you suggested.
Yes.
Then they can conveniently add.
They can conveniently.
But what of where we stick to the 4 years?
To the 4 years.
How do we manage both in a balanced way?
One pathway will be for some courses that we call university-wide courses. Perhaps for the law students. I can see some students shaking their heads and saying, yes, yes. I think that for the law students, we may have to minimize, perhaps not entirely eliminate, but we may have to minimize some of those university-wide courses. That's one option. And then another option would be to beef up or step up the depth at which some of the courses are being taught. For those of us, I can speak about Central University because that's where I work. I know that in Central University, in the final year, students are doing evidence, especially the regular students. They are taking evidence, they are taking alternative dispute resolution. We are doing company law as well. Company law is also being taught at the law school, presently. So if we decide that we want to stick to a 4-year LLB program, then we need to step up the depth at which we are teaching the evidence, at which we are teaching the company law, at which we are teaching the alternative dispute resolution. Those are some of the pathways. And like I mentioned, maybe eliminate some of the university-wide courses to make more room for some of the courses that are being brought down. In Central University, for example, I know the students do ethics, some as part of the university-wide courses. Now that we are introducing the professional elements of the law program, what we can do as Central would be to add the legal aspects of ethical training to the ethics that they are doing. So we've stepped it up. So it's not just the ethics they know it now, but we're going to step up the curriculum to meet the standards of legal ethics and advocacy as well.
Thank you very much for that. You want to add?
Yes, I want to add something briefly. So I'm happy Susan said some of the university-wide courses would have to be minimized. And I'm also happy to say that all the first year's law students, they also do information literacy course, which is also a university-wide course. And that one is an indispensable course aspect of your course, in that you are being trained hands-on skills, a lifelong skills of how to access information or techniques involved in doing research very simply. And I know research will carry you through your education, your practice, your legal practice, and everywhere. It is also a course that teaches you how to use AI responsibly. And so in the era of AI and technology, you cannot take information literacy, which is a university-wide course, out of it. So maybe, yes, some of the university-wide course may have to be minimized, but I know Dean is here, information literacy, my law students, you cannot take it out of it. Thank you.
Thank you very much. Yes, you want to add? All right.
Yes, I just had another idea. So another pathway, like Dr. Francisca Kusiapia mentioned when she had her turn, another pathway to accommodate some of these courses could be for the institution to run them as short courses during summer school, for example. So during summer school, instead of just being on vacation, being home for 3 months, the university could run a short course on family law, a short course on interpretation or something, just to make up for what they are supposed to learn prior to taking the bar exam. But the thing is that the Act specifies the examinable courses, and those examinable courses are all those that are being taught during the LPTC, the Law Practice Training course. It doesn't include any of the undergraduate courses.
Thank you very much for that addition. Francisca, I would engage you. You're a discussant, but in the absence of Dr. Budu, I'll push my question to you. It's also because it's related to the library.
No problem.
And with the two being a blend, in my view, of the UK system and the US system, when I studied in the US, I was shocked to realize that, at least in my university, every librarian must have a law degree. So it made research very easy. Yes, the law librarians, just the law librarian. Every law librarian, everyone on the floor, the staff had to have a law degree. So it made research very easy and interesting. Sometimes they're even proactive in getting resources for you. What do you think of implementing a similar system, at least if not all of them for a start? The lead librarian for probably the law faculty.
For the law
should have
faculty,
a law
yes.
degree. What do you think of that?
Yes, I think GTEC is a recommendation from GTEC, yes. I think at the last GTEC meeting where the General Legal Counsel was here for that exercise, it came up. And so the law librarians, they have started thinking about doing at least a basic degree or a diploma in law. With that, yes, I'm in favor. You understand the concept and you can serve your users very well. So I'm in favor of that. So we are taking steps to do that.
That's good.
And we hope that Central University will sponsor most of the library staff to do that.
They've heard you all. So
Yes,
they
they
sponsor you
have.
to do your
Yes.
LOA.
I'm looking at the Professor Tifa's face.
He's heard you on that.
Thank you.
Okay, now I'll get back to you just on a few issues, then I bounce back to the students. On the staff recruitment, again, the previous panels touched on different areas of the need to bring practitioners on board, others recommending that they should be at least 10 years at the bar and all that. And I was very particular when Jude again touched on that we are focusing on staffing for the LPT, but not staffing for the LLB, where we are pushing the law school courses there. Now, for any of them, if it's being run by the universities have their own criteria for staffing. And how do you merge these? How many lawyers with the experience you require may have the minimum requirements? And again, if we are borrowing from best standards, international standards, the US in particular do not necessarily require their law lecturers to have PhD before you lecture there. Is this something worth considering? They rather place much more premium on experience. And so they have two pathways to law professoralships, the academic one and the practice one. Are these areas worth considering because we are blending these two major legal systems?
So for recruitment to teach the LPTC, I think that the pendulum should swing towards those in practice. We're looking for somebody to teach criminal procedure, civil procedure, law management practice, law firm management practice, and what have you. We should definitely be looking for litigators, people that have firms, people that work in law firms, all right, as opposed to people with a PhD. But then if it's about the substantive law courses that we are already running in undergraduate law programs, then it's all right to ask that the person should have a terminal degree, which is a PhD, or should be working towards one at least. Because at the substantive course, at the level of the undergraduates, when you're doing the substantive courses, it's also about the depth. It's also about the depth, not just about the practice and procedure. It's true anyway that the Act 1170 requires not just a doctrinaire approach, not just a theoretical framework, but people should have hands-on experience. That is true. But I still think that for teaching the basic undergraduates, the core law courses, is still a good one too. So I require that they should have a terminal degree or be working towards one.
If we are to go by that, then isn't it a disincentive to the people, the very people you're attracting? Because if I have a terminal degree and I'm lecturing at the law faculty, because of that, there are opportunities to get promoted and receive some benefits. And you want me to come on board not as a full lecturer because I do not have your terminal degree, yet you need me for your practical side. And I may not enjoy all the benefits because I may not be properly integrated into your employment and promotional systems.
So we would have to be looking at different pathways. Right. Yes, we'll have to definitely have to look at different pathways for the lecturers who are teaching the LPTC and those who are teaching, the LOB. So for the LPTC, we'll be looking at practicing lawyers, litigators, we'll be looking at judges and the like. And then for the substantive law programs at the LLB, we're looking more at people that have chosen the academic path. Yeah.
Thank you very much for that. If I can get your view.
Okay. I even wonder how many lawyers with terminal degrees we have in the system. So as one of the GTEC meetings, I think one panel member raised that we need lawyers with PhDs, and one of the members asked, how many PhDs do you have in your faculty? And said, we don't have any. We've been scouting. And so I don't know if we bring that caveat, we will even get the requisite or the number of faculty members that we need to run this new program. So maybe we have to look at it with those with the practical experience who can teach. Because I heard the previous speaker said, you can get somebody with a practical experience, but he will just come to the class and talk about his experience, his court cases. But we need to blend the practical experience with how the pedagogy, how you teach, how you deliver. that one can also be looked at.
Thank you very much. The balance must be real.
Yeah.
Well, the last issue to be discussed before I get to the floor to the students, it's on infrastructure. Now we are to start. It's in motion. But the infrastructures, even if you have the resources, cannot be put up overnight. Structures in particular. Where should we place premium? Either on the e-resources, because there's a mandatory IT component, or the physical infrastructures, weighing the two, because we've just started rolling and we must start rolling actually. Yeah.
Thank you. So I will say both, but for the start, we can put emphasis on the e-resources in the sense that these are resources that can be used off or on campus. So once we have the e-resources, if I'm not physically present on campus, I can still use the resources. So I will place more emphasis on the e-infrastructure than the physical infrastructure, the space. You see, the caliber of student that we are dealing with, they more or less juggle between work, family, and school and other things. And so during examination period, these are the times that they have the opportunity to sit in a very serene atmosphere, that is the library, and learn. So we need the physical space too, and it's a GTech requirement. And so we need to fulfill that one too. So a blend is good. Yeah.
Thank you very much for your opinion. Okay. Now I want us to move to the critical stakeholders, the students themselves, the direct recipients of all that we're discussing. And my first question, just a question before you now ask questions. How do you perceive the curricula to be like, especially those who are still in the LLB, not the final years? Or how do you want the new curricula to look like? Not to overwhelm you, but we're also not underestimating or reducing the standards in the quality. Any views and ideas on that? Students. Okay, they'll come up with it. Let's ask them questions now. They're not ready to answer my question. That means they are okay with whatever we raise and redraft for them.
The hand at the back.
Let's have your inputs. It would help us and guide.
Yes, so you have a hand from a student at the back. Please, are you a student? I want to get students first. Are you a student? Okay, because for students, let me hear from students first, and I'll come to, are you a student? Okay, I'll come to you.
Thank you very much. Please, my name is Winifred Labienim, and I recently completed my LLB at Pentecost University. Okay, so by way of preface, I would like to say that I believe that quality comes at a cost. And even our key speakers for today and previous panelists have made us understand that quality assurance is necessary in regard to the financial requirements. Finances are relevant for financial sustainability, financial investment, remuneration of lecturers, and whatnot. We understand that. My question to the House then is, what are your suggestions to institutions and stakeholders in relation to financial frameworks that can be put in place to balance the interest of institutions in this regard as against the interest of students and, to that effect, parents who will be bearing the cost of fees? Thank you very much.
All right, I have a few more hands. Yes.
Thank you so much. My name is Benestra Osei Akle. And so I would say that with regards to your question, I believe that more emphasis should be placed on the practical aspects of the law. As an LLB student, most of the things we deal with are more theoretical, but I believe that, yes, and also from the panel discussions we've had, I've heard most of the panelists talking about legal clinics, and I think that more emphasis should be put on that as well. It is equally important that as far as we are learning the theoretics of the legal career, that we should be exposed to more practical sessions, like probably going to the market, dealing with case scenarios, and trying to put our heads together And I think that will do us more good. Thank you.
Thank you. Can I see more hands of students, please? Okay, I'll come to this row.
Thank you. My name is Joseph Yamofio. I'm a weekend student at Miocho. With regards to your question, I foresee a focus on aptitude test. So I think it's a good opportunity for the faculties to concentrate on prepping students on how to take standardized exams, because the pool is going to be bigger, and I just foresee the situation where that will be a core part of the exam going forward. Thank you.
Now, can we take the first three first for them to respond? Okay.
Okay, a lady registered a concern regarding she being a level 400 student and whether she has to return to the school for another semester, or what's her fate. I would like to add that if what happens to those who already have their LLB, what happens to them? Are they coming for another remedial courses for the revised LLB which has been established now, or they just have to apply for the LPT?
All right, please.
Okay,
You may proceed. Yes.
Yes, Susanna is addressing that.
So we'll start with the last question. If I got him right, he wants to know what the fates of those who have completed their LLB. Thankfully, the Act is very clear on that. So when we look at the transitional provisions in the Act, Section 93 of the Act talks about what happens to students like that. So the Ghana School of Law is going to be reconstituted as a directorate, and they have been tasked to run remedial courses for people that have to resist the National Bar exam. And they've also been given the opportunity to offer and design law courses. And I believe that mandate gives them the opportunity to run short courses, even for those whose LLB was deficient in some of the courses that have now been taken away from the professional and brought down to the level of the undergraduate law program. So that will be it for the last questioner.
What about those in level 400 now? That question was asked earlier. I don't think the answer has come clear. What should they do?
For those in level 400 now, it's not too clear exactly what is going to happen. But when we look at the Act and we see that the Act is supposed to take effect, then for those who have finished level 400 just this year, from my perspective and my interpretation, I think we ought to treat them as LLB graduates in the system. LLB graduates in the system. They will have to wait to apply to any accredited institution or to the Ghana Law School to do their 1-year legal practice training course. That's my interpretation.
And that's to happen this September.
Yes, but I think if I got them, the last question and the lady who asked the earlier question, the final years were asking question of what would happen in between relative to the courses that they should have taken prior to the passage of the statute, which they were not taking because the law had not been passed.
Prof wants to help. I don't know.
A requirement for them to apply to the LPT. Yes, thank you.
Thank you very much, Madam Moderator. The Act recognizes an institution called COLD, College of Law Deans. And in terms of the composition of the examining board, for example, COLD is recognized. Now, COLD has had opportunity to look at this dilemma, and the decision or the conclusion is that those courses that should have been taken but were not taken because this law was not in existence and it wasn't a requirement, faculties of law and law schools in general are at liberty within the framework of their own statutes to run courses that that will satisfy those courses that were not taken. And we are calling it the pre-bar exam. So you take those pre-bar courses at the university where you studied or anywhere else in order to position you to apply to do the CLET. The legal practice, LPTC. So it's that simple. You did not take certain courses. The universities or law schools will run those pre-bar courses. Then you take them, you pass, and then you go on to apply to do the LPTC. Thank you, Madam Moderator.
Thank you very much for that explanation. Any further questions? Last two, then we call it.
Yes, from the students. Okay.
Thank you very much. My name is Akusika Eduse. Please, I would like to find out if there's any if there's going to be any form of regulation for fees for students, because we are aware that even though the Ghana Law School is being more like branched into the universities, is there going to be a regulation for fees to make it uniform? Because we are aware it's the same program that's going to be run in all the universities, both public and private. So is there going to be regulation on fees, or the fees are going to be subject to universities? Thank you.
Thank you. Any more questions from students? Any more views? Okay.
Thank you. My name is Jerry Kwega. I just completed level 400 here. Please, my submission is a follow-up to Dean's explanation on the fate of level 400 students who are completing this year or completed this year. So my submission is, given that I, for instance, I'm hoping to enter the law school this year, that's September. We are already almost halfway through June. When am I going to have the opportunity to write or sit for the courses that he mentioned about that the universities will be running for students like myself? Thank you.
Thank you so much. Any outstanding issues? All right.
Okay.
Okay. Just have two more.
That should be the last one.
Good evening, Amadwa. So my question is the LLB curriculum redesign. Some of us are already halfway through the LLB. So my question is, in our last year, would there be like a whole different curriculum, or as Madam Susanna said, a fifth year in addition to the 4 years before we do the LPT? Thank you. 300.
So she wants to know what happens to her. I saw a hand somewhere here. I didn't speak like her, don't mind me. I was trying, it didn't work, you know? Yes, I saw a hand here.
Okay, so my question has to do with the minimum requirement. I would like to know if the minimum requirements for entry into the 1 year legal training is going to be the same for all law faculties. Thank you.
Thank you so much. Moderator, over to you. You may wrap up after this.
So for the last question, is he asking a question?
She wants to know the minimum requirement for entry, correct? In terms of the courses. Say that again. Yes.
Okay, thank you. So my question has to do with the minimum requirements. And so if you want to have access or you want to enter into, you want to undergo the 1 year legal training, what's going to be the minimum requirement? It's going to be so my question has to do with, is it going to be a standard minimum requirement for all law faculties, or there's going to be some kind of variations depending on the law faculty you're applying to? Thank you.
Is that clear?
Yes, we got her question. So the minimum requirements needed to sit for the National Bar exam is going to be stipulated. The Act as at now has not stipulated it, but the Act was clear in saying that the minimum courses are going to be stipulated. Now, for all of us here as law students, we know that usually Acts are accompanied by regulations. The old Act 32 that governed the legal profession was accompanied by regulation and LI. And so this act has just been passed, but very soon there will be an accompanying regulation and LI to make clearer a lot of these things that you are asking. But for now, the act has categorically stated that the minimum number of courses you need to have studied in order to qualify, even for the LPTC, is going to be stated.
Okay. Thank you very much for that. There was a question on the fees to be charged. I'm not sure what Prof's opinion will be, but I think because it's with institutions, it goes to the universities, it becomes more of their decisions to make. Yes, and so definitely it might or it will differ, as it even still is now. Thank you all very much for joining us. I will not be the reason for keeping you famished. Thank you very much for helping us fill in the few gaps that were left. Thank you for having us.
You gave the applause without instructions. Can you do it now? Thank you so very much. Ladies and gentlemen, as we initially mentioned, we had to take a detour because of how we could not keep up to the time. We should have had paper presentations. Unfortunately, once again, because of time, we are unable to do that. But let me invite Mrs. Eunice Sapia-Sari. She is the Academic and Program Subcommittee Chair for the Colloquium, and her duty is to acknowledge papers submitted and their authors. Thank you very much, Madam.
Thank you very much. Good evening, Mr. Chair. Several papers were submitted in response to our call for the colloquium. Because of time constraint, we are unable to present it. There were 4 papers that were accepted by the colloquium, but we couldn't, these papers are unable to be presented. So I'll just mention the paper titles, then I'll mention the authors, and then we acknowledge them, please. So the first paper is titled Quality Assurance Standards in Legal Education, Maintaining Quality Amidst Extended Access under the Legal Education Reform Act 2026 Act 1170. This is by Andrew Kofi Annan. Andrew is not here, so I was supposed to have done his presentation for him, so I couldn't do it. And the next paper is Student Access, Progression and Outcome under the Legal Education Act 2026, Act 1170, Reform Imperatives, Institutional Obligations and Architecture of Inclusive Legal Training in Ghana. The authors are Eunice Sapia-Sari and Cynthia Mokwa Ajiman. The third paper, thank you, was ICT Integration and Hybrid Learning Systems in Legal Education Reform, Evidence from Central University Ghana under the Legal Education Act 2026. This is by Reverend Dr. Charles Ni Ashite Amano Kome. if Dr. Kome is here. And the last paper that was supposed to have been presented is the legal reform and examination malpractice in Ghana, higher education, a qualitative case study of institutional preparedness at Central University Ghana under the Emerging Legal Reform Education 2026 discourse. This paper is authored by Reverend Dr. Charles Ni Ashiti Amanokome, Mrs. Ruth Afo, and also Mrs. Lily Nutako. So, because of time constraint, Mr. Chair, these papers couldn't be presented, but it will be added to our colloquium package for anybody that will want to read them. Thank you very much.
Thank you very much, Eunice Umaru.
Thank you so much.
How come I'm reeling under the impression that the students are not very satisfied as to the way forward? Do you share the same feeling?
Yes, I think they are still confused. I think they are confused because I am not confused. Small, but not plenty. I don't think they are confused. What I'm trying to say is that the issue is a new law. We are all learning. We've probably not all read the whole act. So there's a lot more to be done. But I think the LI has been passed, and that LI is what will be regulating the whole. So we wait for the LI to be passed.
Advice. That should be the advice, that we all wait till the LI is passed. And so if there be any persons here who are members of the council, if you can expedite that action, because the students want to go to school. We are in June.
Yes.
And next month will be July.
I know what's exciting about June is a World Cup.
Okay.
In the year 2006, the World Cup was in Germany. Ghana was going for the first time. And I was happy to follow.
Okay.
And you know who I listened to?
Who?
A brilliant voice on Joy FM. I was a cowboy in the village then with my small radio sets, listening to Eva Autry deliver commentary on the World Cup.
And Eva is here with us.
And Eva is here with us. She's a lawyer, journalist, and everything. Thank you so much. And she's one of our rapporteurs for today. We also have Francisca Kakra-Forsen, also formerly of Joy FM. Why? Now it's City FM. Thank you, Francisca. And then Reginald Ni Odoi. Okay, baby. But we have Hepzibah. Hey, Hepzibah. That sounds Jewish. Hepzibah Korte. Where are you, please? Level 200 Central Law School. She's at the back. I'll come and learn how to pronounce your name. So they did a brilliant rapporteuring work for us to put everything together. Thank you so much. I think we started with the chairman's acceptance. We have to close with the chairman's acceptance. Otherwise, no lunch, no closing. Okay. So we should invite chairman. Hello?
Nakai.
No, you are not. Chairman of the colloquium, please kindly come and tell us if we've done a good job or not so we can close. Thank you. Ladies and gentlemen, let's welcome him.
Thank you, Umaru. Need I say that Umaru interviewed me, how many, was it 2 years ago? And that so the two of us, so our interview on legal education, I believe 2 years ago or 3 years ago, yes, was rated as the best interview on legal education. Anyway, I know I almost spoiled the appetites of majority of the students here this morning when I said you shouldn't be scared of exams. Trust me, I think if I had the opportunity, you write exams. You will. Anyway, all too soon, getting to the end. I've just whispered into the ears of Ken. I believe this should have been 2 or 3 days, so that we would do justice to the theme of this colloquium. But be that as it may, a lot has been said. At least we all believe and share in the idea that the act is very progressive at this stage of our legal life in this country. But there are a few gray areas. The last 2 questions, for instance, on fees. An airline will soon be passed to address the issue of fees. Maybe before the budget is read, because the finance minister has hinted that we need to know the size of the purse in order to determine the way forward financially. So I believe, that in the not too distant future, an airline or the desired airline will be passed, and then we'll all know where we stand. As to the transition, the dean, your dean, and Dr. Kwanzaa, who took part in synchronizing the act, will be in a better position to address these concerns after today, so that we from Mount Crest don't say anything that will conflict or contradict what we are doing here. But I can say one thing, that Central Law School is very well positioned as regards the philosophy of the program. And the philosophy of the program is learning by doing. That is why we are going to have clinical legal education clinics. And you are very well positioned because you have the whole Agbogbloshie market, as part of your surroundings. And that is where small claims issues may arise. And I've been in the forefront fighting for final year students in the CLET to at least be able to go to court and do live cases under supervision of senior legal practitioners. And this is one area, that will be food for thought. And I think that I will recommend to the General Legal Council to begin assessing places like this where our students can give advice, pieces of advice to market women, to their children, to traders, to suppliers of goods, to start, the journey, the art of persuasion, the art of giving opinion, the art of drafting, and this thing. So if you don't believe that you have a very, very good place to study your law, I am telling you that this is one of the best places, that we can. So now let me return to all that has been said today. The gray areas relate to the following, and I think that Professor Kanatifa and organizers, who do, very well to capture these things in their package, to be forwarded to participants. And I think that will be very good. In terms of vision, we all share the vision that at the end of the day, we are striving for excellence. And that is, at the bottom of, everything that we done. Then in terms of readiness, the concerns have been whether we are ready in terms of infrastructure. Are we? And the consensus is that some may be ready, others may not yet be ready. But for those who are ready, perhaps, like Central, they can apply and begin the program. Those who are not ready and maybe waiting can take the transition period to get up their loins and give themselves some time so that they can also be ready to take off in, let's say, a year or two's time. So it all depends on the readiness in terms of infrastructure, in terms of facilities, in terms of resources, in terms of staff capacity development, accreditation, quality assurance, collaboration, and all that. So in terms of readiness, it is uncertain. Some may be ready, others may not be ready yet. But whether we are ready or not, we are all agreed that the time has come to reform in legal education. I'm glad that next year will mark my 50th year in legal education. Started teaching in the university 1977. So next 2027, 50th milestone, dedicating my life, 50 years of my 75 years to legal education. And I can tell you that the journey has not been that smooth and sailing. So for my dear students who are clamoring to enter the clergy and become lawyers, my advice is tarry a while, poco a poco. You will get there and you see that the enthusiasm, the zeal, the happiness, the excitement, the joy will be short-lived. And then you begin to ask yourself whether you made a good choice after all. So it isn't all going to be something that at the end of the day, if you hurried into it, you will not regret. So let's take our time. We'll get there one day. And it reminds me of when I decided as director of the Ghana School of Law to establish the law faculty at Tech. Because at that time, there was only one law faculty in this country, located in the University of Ghana, Legon, where I was educated. And then one law school at Makola. And I thought in 2002 that it would not go well for the country's fortunes. Therefore, we open up Tech, University of Cape Coast, then UDS. Today, I'm very, very excited that I'm taking part in a colloquium that is likely to lead to widening access to legal education. And should that happen, maybe we should all begin thinking of whether the time has also not come to establish law schools in our rural areas, so that the over-concentration of lawyers in Accra, Kumasi, Sekondi, Takoradi will be a thing of the past. As we talk of widening access, as we discuss expanding the curriculum, as we begin to divide the frontiers of legal education into two compartments: the LLB level, where PhD holders have to teach, and the training level, where experienced legal practitioners must teach. The line is, all of us must be honest in confronting the challenges ahead in terms of recruitment of staff, in terms of acquisition of library resources, in terms of motivating staff, teaching and non-teaching, and students, in terms of whatever we need to produce the next generation of Ghanaian lawyers who will be fit for purpose. The journey of 1,000 miles begins with the first step. The reform is the first step. Let us take it that as Ghanaians, we want the best for ourselves. It is up to all of us. So at the end of the colloquium for today, what as chair I can pinpoint is that we are ready to take off. Thank you.
Thank you very much, sir. When it comes to matters relating to this new regime, I've always said that we should be guided by the saying that goes, where there is a will, there is a way. If we want to operationalize this new regime, we will be more than able so to do. Thank you very much. I will be inviting Mrs. Lily Yeboah Nutako, Registrar Central University, anytime soon. But before then, because I took away your lunch, let me give it back to you so that nobody carries ill feelings to their various places. So we're going to have lunch, but I'm told that this lunch will be packed. The lunch was supposed to be lunch and networking. As for the lunch, I'm sure people will take. The networking, I'm not too sure. But if you could spare a moment and do that, that would be also fine. So what we're going to do is that we're going back to where we went during the health break for the lunch. And so let me now invite Lily to come and give us the vote of thanks.
Good afternoon, everyone. It's been such a great day. I whispered to Mrs. Francisca Asante earlier on that the way the lawyers are talking, I'm beginning to feel like I should go back to school and do law. It's been a very insightful one. Mr. Chairman, I will stand on the existing protocols we've had since morning and deliver what I've been asked to do briefly. On behalf of management of Central University and the Central Law School, of course, the organizing committee of this colloquium, I have the honor of doing this. We extend our deepest gratitude to His Lordship Justice Paul Bafuboni, the Chief Justice of Ghana, for his insightful, keynote address, and to our distinguished chairperson, Mr. Kweku Ansasari, for presiding with wisdom and with grace. We also appreciate Her Ladyship, Justice Sophia Kufu, and the advisory board of the Central Law School for your invaluable support. To our esteemed guests from the legal fraternity, judiciary, the Ghana Tertiary Education Commission, and from our sister universities, thank you. Thank you for honoring us with your presence. Now, a special thanks go to our speakers, our panelists, moderators, discussants for enriching today's program, and to our students and participants for your active engagement. We are equally grateful to our sponsors, our partners, and support staff for your commitment. Finally, we salute Professor Kenneth Ajimanatefa, the Dean of the Central Law School, Professor Clarissa Jeha, the Director of the Christ Temple Campus, our faculty and staff, and the organizing committee for your dedication in making this special colloquium a success. God bless Ghana. God bless Central University. God bless the Central Law School. And God bless us all. Thank you and have a good afternoon.
Thank you very much, Lily. For the avoidance of doubts, if I may go through this again, all judges and special guests, you are proceeding to the VC's lounge. All advisory board members will be at the holding area within the VC's lounge. Deans and directors and staff of Central University will be at DI2, and students, multi-purpose hall. Umaru, where will you be? We are not part. We are going to Abosokai. Right. Okay. I remember when we were in the law school, as Mr. Ansasari said, there was only one law school campus. It was Makola. So if you were going to law school, you could say that you are going to Makola, and people will understand. Now people are going to say they are going to Abosokai.
Okay.
Yeah. Hello.
Abosokai, Nakai. So I'm Ghana School of Abosokai.
But no.
Central
University.
No, but it's now national. So Central Abosokai Law School.
Lawyer Abosokai.
So Abosokai,
no, it's okay.
Yes. But Miocho is also there. So we have to put the two together. Miobosokai.
Okay. I'm not here.
But you know the problem with the food thing, eh? If you have ever been an MC, you know that when it comes to food, they don't consider you.
Yeah.
They will tell you, oh, announce that this car has blocked this thing, you announce.
Yeah.
Announce that these people should go and eat here, you announce. But they will not say, announce that MC is going. So where are we eating? The problem is that this used to be a church. You could have gotten food here. It's no more. You have to go to Chado. Me, the Central Mosque is just here. The Abosokai Mosque is here. I'll go and eat there. Okay. So over to you.
Over to me.
Anyway. TK didn't tell you, for he used to be a journalist many years ago, before I was born.
Oh, I thought I'm still a journalist.
No. Once you became a lawyer, you stopped.
I thought they said once a journalist, always a journalist.
No. If Aochiri is no more a journalist, you're also no more a journalist. So Francisca Kakrafos is no more a journalist.
Oh, okay.
All those journalists who became lawyers, they are no more journalists.
They are no more.
Very soon, media will continue to be a journalist.
No, you'll be no more. So, ladies and gentlemen, we will rise for the university anthem. For those of you who may find it difficult, we're going to project the lyrics on the screen. So we don't want anybody to be just, moving their mouths anyhow. So watch and then join in.
As an old student, I'm not proud to say I cannot sing a word of my school anthem. So I'll just keep quiet, or I'll be miming or something. So ladies and gentlemen, those looking at the screen, you can sing. I also just stand. Thank you.
The anthem.
We live where dreams are born. Hear bold eagles set sights on higher to welcome a new day. Oh Spirit of glory, stir us up your heart to later on our fields and shining lights of Christ. Lord, bless and keep us ever by your hand. Guide us to learn, to live, to lead, and not wavering. Reach beyond the stars. Lord, bless and keep us ever by your hand. Guide us to learn, to live, to lead, and not wavering. Reach beyond the stars.
Thank you so much. You may please resume your seats. Thank you. Hey, I like how the dean, vice dean, and the staff were singing, and the students were miming. Dean, please, you should do one whole week of anthem teaching so that they will learn, and then they will sing so that they will be proud. Thank you so much. TK, are we done?
Yes, we are done. So please, let's all head to where we have been asked
Before
to.
they go, we have to say who we are, so that if someone wants an MC who will pay, this one they didn't pay us, it's free, pro bono. See, a lot of people, everything pro bono. So we've done pro bono MC here, but we collect money to MC events. So my name is Umar Rusanda Amadou. I'm a journalist. You can find me on social media, anywhere, DM me, and I'll come and do your program for you, not for free. Unless you are Prof. Atifa and you call down there, I can't charge you. But Prof, I'll send you a bill. TK.
My name is Chunipo Akodia. I'm a lawyer. Thank you.
Thank you so much. Have a good evening, everybody. The control room is just showing us that we are on the screen. But this one is after the program now. Okay, so yeah, our names are there in case you want to find us. Thank you so much. Thank you, Evans and the team. Thank you so much.